Hi, everyone. Welcome. Folks are joining the call right now or joining the meeting right now. So we're going to give everyone a couple of minutes. I'll repeat this welcome a few times. Welcome, welcome, welcome. We're excited to have you and get started. And we'll start in about 4 minutes. So feel free to grab some water, grab a drink, get settled, and we'll start at 12:05. Hi, everyone. Welcome. For those of you just joining, we're really excited to have you here. We will get started with our event at 12:05. So feel free to grab some water, get situated. We'll give everyone a few more minutes to join and we'll get started right at 12:05. Thanks for being here. All right, it's 12:05. Welcome, everyone. Thank you for bearing with us in that weird silent space in the 5 minutes before an event. We're so excited to have everyone here for our discussion on non-disclosure, non-exposure, and how NDAs silence workers in tech and beyond. I'm Samantha Gordon. I am TechEquity's SVP of Organizing and Advocacy, and I'm so honored to be here with you today and with our two fabulous panelists. And also just want to name that this event was going to be moderated by our incredible senior policy manager, Hannah Holloway. And unfortunately, she wasn't feeling well today, so I am her stand-in. So please bear with me. I will do my best to channel Hannah and all of her great work on these issues. So before we dive in and get a chance to really hear from our panelists and dive into this, I wanted to just orient anyone who's new to TechEquity and what we do. So at TechEquity, we engage tech workers to take action on building an economy where everyone benefits from the growth that tech has created. And we do this really in three ways. We do education with events like these and other sorts of programming. We do public policy, which we'll talk about on today's meeting. And we work in partnership on that with other community groups and partners to advance public policy that promotes structural change. And finally, we do some corporate policy where companies who are willing to do this work and want to work together, we work with them to improve their corporate practice to benefit their employees and hopefully all workers. And the two areas we focus on are housing and labor. And we love being able to do events like this and bring our members and larger community together. And if this is work that you support and believe in, I would ask you to sign up to become a member of TechEquity. You can do that by contributing $10 a month or $100 a year. And we really, really appreciate all of the support from our members and our community, helping to make sure we can have these sorts of conversations. In terms of housekeeping, there is a chat. You should feel free to have conversations in that chat. I do want to let folks know that we operate from a code of conduct, which Herman, our community manager, will drop in the chat. And basically what it says is we're trying to create a safe space for difficult conversations. So please be respectful of other participants in the chat and be willing to share space in a way that's not destructive, please. And then finally, our questions for our panelists. There's a Q&A button. I think everyone's familiar with our Zoom world now. Please, for questions you have for our panelists, put them in the Q&A function at the bottom of the screen to make sure that we don't miss them. And we'll do Q&A at the end of our discussion. So context, why are we here? We are here really to discuss the effect that non-disclosure and non-disparagement agreements can have on workers who experience misconduct and unlawful treatment in the workplace. I know I've worked in labor for a long time. NDAs, non-disparagement, are very wonky terms and kind of get confusing for people. And so what we're going to try to do today is kind of ladder up to what these issues mean, what kind of impact they have on people's lives. And we'll try and dissect this issue a little bit to help people understand the nuances of this. And I think, it's helpful to frame this conversation within the context of how many companies put out public-facing statements over the last year that both within tech and outside the tech around the Black Lives Matter movement and expressing a lot of support, while at the same time employing corporate practices that were harmful to Black workers, not to mention other workers. So a lot of these, public-facing statements would say the right thing and be imbued with values that many of us share, but at the same time, things like NDAs and discrimination were not allowed to be voiced publicly and for companies to be held accountable to those practices. And that's really where the conversation around non-disclosure and non-disparagement fit in this broader context. And I think our panelists can talk about this in depth, but to do a quick overview of kind of what that means is that there are agreements that workers sign sometimes when they join a company or organization. It's written into their contract. Sometimes when they're leaving, either amicably or for a termination, they will sign them. And essentially, a lot of those agreements have clauses in them that prevent workers from speaking out, not just about, maybe company secrets, trade secrets, company information, but also about their experiences of discrimination and workplace misconduct. And there is currently a bill, which we'll get into in the California legislature called Senate Bill 331, that would allow those who have experienced discrimination or unlawful harassment to speak about it publicly without violating an agreement to protect company trade secrets. Ifeoma and Mariko will talk about that in depth. I don't want to get too far out in front of our conversation, but did want to situate people into sort of this current moment and how we're coming into this conversation. And this particular bill you'll hear about was born out of Ifeoma Ozoma's experience, as well as Erica Shimizu Banks' experience, who provided whistleblower accounts of their experience at Pinterest and sort of really working to shape novel corporate practice around, real core justice issues as part of the public policy team and their treatment as a result. So I'm going to stop talking about context and I'm going to hand over to our panelists to introduce themselves, and then we'll jump right into questions. So Mariko, do you want to go first?
Sure. Thanks. Good to be here, everyone. Mariko Yoshihara. I am the Legislative Counsel and Policy Director for the California Employment Lawyers Association. We're an association of plaintiff side employment lawyers representing workers like Ifeoma. One of our members represented her And we also do a lot of public policy work, sponsoring a handful of bills every year, like SB 331 this year. We've worked on legislation around equal pay, sexual harassment, race harassment, and discrimination, also wage and hour, whistleblower protections, so kind of the full gamut of workers' rights protections. And I've been doing that for the past 11 years now. And so really, it's been a privilege to work with Ifeoma on this really important issue. So I'll pass it over to Ifeoma now.
Thanks, Mariko. I'm so excited to be here along with Mariko. We talk almost every single day about the bill, so it's exciting to speak with other people about it as well. Like Sam said, I was most recently at Pinterest, but before that at Facebook and at Google, working on tech policy issues. And the experience that I gained from those companies is part of what I'm using in co-sponsoring the bill. And one of the things that I think is important, and we'll get into more detail about this later with Sam's questions, is codifying protections like the protections that workers would get through SB 331, the Silence No More Act, is important because you shouldn't have to have public policy experience. You shouldn't have to have connections with press. You shouldn't have to have a legal background to protect yourself and to know your rights. And right now, employers know that the balance of power lays with them, both with knowledge and with resources. And what this bill is trying to do is balance that a little bit more.
Beautiful. Thank you both for being here. We're so honored and just so excited to be partnered with you on this bill and help in any way we can. So I think to kick us off, I mean, Ifeoma, you're going there in your kind of intro, and I know I mentioned it in the context setting, but you've really used your personal experience to sort of champion what needs to happen around this issue. And it's been, well detailed. You mentioned your ability to work with the press. It's featured in the Washington Post, the Guardian, the New York Times. And I wondered if you could just talk a bit about sort of the background and why you chose to advocate on this issue and how it connects to your experience.
Yeah, as you said, it's been well documented, but while I was working at Pinterest pretty early on after starting there, realized that I was being criminally underpaid. I did all of the things that employees are told to do, brought it up with my manager, with my manager's manager, who happened to be and still is the general counsel of Pinterest. Brought it up with HR, with a team within HR that is supposed to work with employees, before I then finally hired my lawyer, Peter, who is part of the California Employment Lawyers Association. And even then, the way we approached the company was, we want this solved amicably. We just want the pay fixed. Like, we want these things addressed. I was doing my job the entire time, a very public facing role where I was working with reporters on the health misinformation and other policy efforts I was leading at the company. And so everything pointed to it making common sense for the company to resolve my issue internally and quietly in the way that I wanted. What instead happened is, after raising complaints with the Department of Fair Employment and Housing, retaliation became really intense. I was eventually pushed out at the beginning of the pandemic in March of 2020. And it was at that point that I was basically presented with one option or no option. You either sign this agreement that includes an overly broad and overly restrictive non-disclosure and non-disparagement agreement, or you get no health insurance and no compensation and no ability to even have a little bit of breathing room to figure things out right at the start of a global health pandemic. And that's a position that a number of workers were put in when they were laid off, when they were pushed out, maybe for existing concerns that they had raised. And what I am afraid of is that there are a ton of stories like mine that we will never hear from this past year, because people just did not have the choice to turn down health insurance or money when they were entering a pandemic.
That's really helpful. Thank you for sharing that. I think it'd be helpful, Mariko, if you could kind of talk about the landscape of this, like you said, CELA, the California Employment Lawyers Association, works on workers' rights issues in tech, but across all industries. And there's been this incredible effort that you all have led to sort of fix NDAs. And one of the common talking points we get back, I know lawyers have said it to me when I've been, a manager, is that you have to put these in place to protect trade secrets and intellectual property. And I wonder how you all are speaking to that, both in the legislature and how you speak to that issue as you advocate on this topic.
Yeah, I mean, I think it's really misleading and dishonest, that concern and that talking point. As Ifeoma and I think a lot of people probably know, that those types of confidentiality agreements that deal specifically with proprietary information or trade secrets, those are separate and distinct confidentiality agreements. So this idea that this is somehow going to prohibit employers from using those agreements is, again, very dishonest, because we're very specific in the language that we're using in our bill. We are talking about agreements that are going to prevent or prohibit a worker from talking about unlawful activity, including harassment or discrimination. And we are so specific in terms of what we're covering in this bill. And, I can't imagine, that there would be an argument that an agreement, a confidentiality agreement covering proprietary information and trade secrets, could ever be construed to mean you can't talk about harassment or discrimination. Nevertheless, given that those concerns were raised, we actually put specific language in the bill that says employers can still have those types of confidentiality agreements. So we've actually dealt with that very squarely in our bill. So I think, just why what we're really seeing just as a trend, I think, is employers really just using overly broad, just kind of this catch-all confidentiality agreements. That another problem, and as I'm reading more and more articles, and thanks to Ifeoma for really raising the profile of this issue, they're becoming just like boilerplate. People are pulling them off of Google, so they're really being inserted into every sort of agreement that we're seeing. And the main problem is what is this covering? What can employers not say? And so that's why I do think it's really important to be really clear and define how restrictive and what do those confidentiality agreements really cover, and be extremely clear, especially to employers. And we even in our bill, we have language in there saying you need to include this specific language in any confidentiality agreement, so that workers who are signing them understand that this doesn't mean I can't talk about harassment or discrimination. And just to give a little bit more context too, we worked on this issue in 2018 during the Me Too movement. We worked on a number of bills, but we were seeing that a lot of employers and companies and high-profile individuals were requiring workers to sign these broad confidentiality, non-disparagement agreements as a condition of their employment, when we know that there was rampant harassment and discrimination happening. One specific case that we saw, the confidentiality agreement had a $1 million liquidated damages clause. So the worker was so fearful of saying anything, because that could mean, Ifeoma was talking about signing these agreements and not getting healthcare and not, potentially not getting a severance payment. In some situations, these workers have to sign these agreements and are afraid that they're going to be, that the employer, or the company, or this individual is going to come after them for $1 million, for saying something that unlawful, talking about something that unlawful that happened to them. So again, really with this bill, we're being very specific. We just want to be very clear that corporations can't use these types of agreements really as scare tactics, scaring workers into silence.
That's really helpful, because I think as we've talked to members and folks about your bill and about NDAs, a lot of the questions have been around, do the NDAs, could companies still use an NDA if this bill goes through to keep you from suing? Like, companies say there's a lot of like wrongful litigation that comes, those sorts of things. And so it sounds like it's pretty prescribed that the piece you're removing is the disparagement, right? So being able to say, if you experience discrimination or unlawful conduct, you can speak specifically about that without violating an NDA. Am I understanding it right?
That's right. I think an important distinction to make here is that companies can still include the release of claims, which is what the company gets as the benefit for you signing an agreement. So as a company, you cannot tell someone you can't speak to truthful experiences that you had about unlawful acts that you experienced or you were the victim of. But what you can do as a company is say, this person is signing away their right to sue me in the future based on their experience. That is still lawful. That is the case under this bill. And so companies really aren't losing anything other than the ability to silence people about unlawful experiences.
Yeah, and I would just add, it also doesn't ban non-disparagement agreements. Because again, the problem has been, what does disparagement mean, right? And so if I'm going to talk about harassment or discrimination, my supervisor harassed me or my coworker harassed, am I disparaging that person? So it's like getting caught in that gray. And I think it's purposefully vague and confusing to workers because workers are more often going to err on the side of staying silent. So what we wanted to do is better define what disparagement means in terms of how the employer can use it and how they can't use it. So you can have a non-disparagement provision. Employers are free to use it to just say, you can't just make general disparaging comments about the company, this company sucks, just like general comments, but that can never be construed in a way that prevents a worker from talking about, I was harassed, I was discriminated against. That can't be considered disparagement. So defining that a little bit more clearly so that workers feel more freely to speak.
That makes sense. So kind of putting bright lines for those workers that need to whistleblow, that need to hold, individuals or the company accountable for unlawful behavior, making it clear for them so that, like you were saying earlier, Ifeoma, it doesn't take a extensive background in public policy and media training to be able to do that without a lot of fear. I think that's really, really helpful.
Exactly. Yeah, and one of the reasons why we added, so this deals with NDAs, as a condition of settling a claim, but then also as a condition of a severance, because, a lot of times our bills are obviously informed by very real life experiences, and Ifeoma's was one, and Erica's was one experience that I know, again, a lot of workers were dealing with, but then also at the same time, like during the pandemic last year, and then so workers are getting laid off. At the same time, we're having like a major reckoning around racial justice issues, systemic racism. And, we had workers who were asking, okay, I'm getting laid off. These companies are talking about their commitment to, racial justice. And I want to talk about my own experience as a worker in this company. And I'm signing this non-disparagement agreement. Does that mean I can't talk about it? Literally having to go to lawyers to figure out what that means. And so we're advising them, well, maybe have a back and forth with the person who's requiring you to sign this. Like, hey, can I talk about my own experience? And even that back and forth, again, it was like probably this training of just stick with like very vague and confusing responses so that the worker is just going to err on the side of staying silent. So it just became very clear in that moment when workers really should be speaking out that we need to make absolutely clear that if you're talking about harassment or discrimination that happened to you, that is not going to be any violation of a non-disparagement agreement.
Yeah, and I think that's a good segue actually to Ifeoma. I was wondering if you could talk about, you were in that limbo, right? Because you had signed one and then you decided to go public shortly thereafter. And I know, given what Mariko was just saying, some of what you had shared and some of the reporting I read was that part of what spurred you was Pinterest's public statement around Black Lives Matter. And I wondered if you could just talk about sort of what compelled you to break the NDA. How did you kind of go about that? How did you make that decision? Because I know that's a really risky decision, as we've talked about.
Yeah, it was and still is. I'm fully in breach of the agreement that I signed with Pinterest, pretty much every single part of the agreement, in speaking up about what I experienced there and continuing to do so. And so there was the risk at the beginning that I spoke to Peter about, and he was very clear about what the risk was to me and the document that I signed. I was fully aware of what I was signing when I did. But it was still a decision that I felt was right for me, not a decision that I would make for anyone else or that I think anyone else should make without being fully aware of what the consequences are. But that should not be the case. That is the whole reason for this bill, that you shouldn't have to debate, like, what would it cost? Even if a lawsuit was thrown out eventually, it'll cost a ton in terms of money, in terms of time that you may not have if you're starting a new job, and in terms of resources that most people don't have available, just to get to the point where a judge says, you know what, actually, this contract was too broad. And so the reason, like you said, why I spoke up at the time that I did was because Pinterest made a Black Lives Matter statement that I thought was just totally hypocritical and disingenuous. And now we have a rainstorm. So.
Oh. I wish we had that here in California. Yeah, I think that's what we've been hearing too. I know I mentioned earlier, I've been a labor organizer for a long time, and sort of making those calculations is tricky. So really going in clear-eyed and having this legislation that can make it easier and less stressful for people to be able to speak about what happened. I wonder if we can kind of turn there. I know you both have talked some about what the legislation covers and doesn't cover, and I wonder if you can just share a little bit more about the bill, where it's at right now, kind of the intent, what you're hoping will happen with it.
You want to go for that, Ifeoma?
I mean, long story short is where we are right now is it is up for its final big vote in the California legislature. It's been passed out of the California Senate. It was passed out of 2 committees in the assembly, and it's now up for an assembly floor vote, which will probably happen when the assembly is back from recess.
Congratulations, that's huge. For those that haven't worked on legislative politics, it is very hard to get to that stage. So congratulations to you both and everyone who's worked on this. Go ahead, Mariko. Yeah.
Oh, I was just in terms of also what the bill does and doesn't do, like what it covers and doesn't cover. So the bill, as I mentioned before, deals with settlement agreements and severance agreements. So those are the agreements that we're covering. But specifically for settlements, which are like very specific NDAs that workers have to sign. So just by way of context, in 2018, a bill was passed, Senator Leyva passed a bill that prohibited NDAs in settlements of sexual harassment, sex discrimination, sexual assault. So now we're expanding that out to any form of harassment or discrimination. And I just want to make that point because I think just in anybody who's involved in policy making, in 2018, we were very intentional about making sure that as we're strengthening our harassment laws, that we are being very mindful of intersectionality and the fact that, this is not just a sex harassment problem or a sex discrimination problem. And so what's great about this bill is that we're building on that concept to include all forms of harassment or discrimination. So race harassment, harassment based on sexual orientation, disability, age, all the protected bases under our discrimination laws. And then on this, so it is still limited though. I think eventually probably, the gold star would be, you just can't have an NDA, because I think we can all talk about the public policy, what does it make good public policy to silence workers about unlawful activity that they faced. And so, general whistleblower claims or a wage theft claim, things like that, those settlements could still have NDAs. And then the other thing that's what this is covering that's new is like, as I mentioned, the sort of broad non-disparagement confidentiality clauses that are required as a condition of severances. And that builds upon other work that we did in 2018, because I don't think a lot of companies realize that you can't actually have those broad confidentiality clauses as a condition of employment. I hear that employers, especially in tech, I think still are using them. So what's good about this is that we're trying to build awareness around the existing laws banning those types of agreements, but now we're also expanding it to cover severances too.
That's great. And one of the things we noticed was, it was reported, I think Megan Rose Dickey, senior reporter at Protocol, reported that about 65% of tech workers are under some form of an NDA compared to approximately a third of the overall workforce. And one of the things I think is notable about your bill is that, one, it's not focused just on tech and there's no industry carve-outs. And I wondered if you could talk through the thinking on that, because I know a lot of times different industries and different businesses will make cases on public policy that they need a carve-out. And so just wondering, why you chose to use that approach and kind of what your hope is with doing it that way.
You want to take that, Mariko?
Oh, I was looking at you.
Oh, yeah. I mean, I can say really quickly, and I hope it's not too loud. I might get up in a second and close my windows. This applies, and actually, I think this answers one of the questions in the Q&A. This applies to everyone. Contract worker, whether you're working with someone for one day and they have you sign an agreement, I think it's important to note that it's not just folks who work for large companies who are forced to sign NDAs. You can work as a nanny, a babysitter, a chef for someone in a very short-term period and for under a contract and be asked to sign an NDA as part of your employment. So this is all employment and all housing contracts as well.
Great. I don't know, Mariko, if you have anything you wanted to add on that.
Well, I was going to say the NDA, this is where, again, like I try not to get into the weeds on this because it can be confusing. There's so many different agreements. A lot of them kind of overlap, but on the NDAs as part of settlements, yeah, that really does apply to all workers. The agreements that are required as a condition of employment, it does, there could be some questions in terms of independent contractors, whether they would be covered, because that section that's under our Fair Employment and Housing Act does govern traditional employment relationships between employer and employees. But so that said, those specific protections, I think, would be for employees. But there are also other protections too, like both under federal and state law. I think any sort of restrictive confidentiality agreement is sort of frowned upon if it's going to prevent, collective action or, workers talking about their working conditions. But generally, just in terms of the non-disparagement, that it is, that part of our anti-discrimination laws really are focused on kind of the traditional employment relationships.
The point I was going to make to that, though, and I may have missed it when I went to close the windows, is even if you work for Facebook and you're a contract worker for Facebook who's working in the kitchen, but you work for Aramark, your employer Aramark is still covered by this law. And so if you're based in California, you're covered, period. It doesn't matter who your employer is.
Great. Well, I think on that point, I'm curious, I know, Ifeoma, you've called for companies that have supported the bill to proactively put that language into their corporate practice. And I'm curious if you can talk about, has anyone taken you up on it? Have they done it? What are you seeing across the corporate landscape so far?
Yeah, this is an opportunity for others who are listening to do so as well. But I was on a panel, a protocol panel a week ago, 2 weeks ago now, with the Expensify CEO, David Barrett, and just asked him the way we're talking now, whether he would include the language from the bill in his global employment agreements. And he said yes, because it makes good sense. And if you aren't trying to hide discrimination and harassment, then you should have no issue including this language in your employment contracts. And I'm right now working with Open Mic and Whistle Stop Capital to get other companies to do the same, because it's important that we'll have, hopefully, these protections in California soon that'll cover California's 40 million residents, but that doesn't cover the folks who work for Apple and live in Georgia, or who work for Facebook and live in New York. And so we want to make sure that employment protections are across the board and not just jurisdiction by jurisdiction.
Great. Well, and I want to make sure to reserve time for the Q&A that I see popping from folks in the audience. But I guess two more quick questions, hopefully, before we go there is, hopefully this bill gets passed and gets signed by the governor this fall. And I'm curious, Mariko, you made mention of how we could build on this moving forward. If you all already have your sights set on sort of what comes next and how you continue to do this. And it sounds like the company piece is part of that. So just curious if you can give window into where we go from here, pending successful passage.
Yeah, that's a great question. Because we're so focused on reaching the finish line on this bill, which, I hope by September, we have a signature on this bill. But as I mentioned, there have been efforts at the federal level, and I think in various other states, to pass broader limits on these types of NDAs. There have been attempts in the past to prohibit NDAs just broadly in all settlements. Again, both at the federal level and at the state level, really, targeting the public policy again. I think if it makes sense for harassment and discrimination, there's a lot of other unlawful conduct that I think really we need to shine a light on, like especially on like whistleblower action and that type of thing. So not just in the employment context too, like in the consumer context, there are a lot of examples where you have an unsafe product, babies have died, like really awful things where they bring an action, like a wrongful death action or something, and then that gets, there's an actual NDA so that other consumers can't be warned about, some dangerous product that's out there. So I think just, kind of expanding the scope out just in terms of how these NDAs are really used and how they insulate employers from accountability, both legally and public accountability. I sort of see, taking this fight on, more broadly in that way. And then just, I think in terms of, like Ifeoma going, talking to different employers and really, I think ultimately what we saw just over the past couple of years is a lot of companies, pay lip service, saying that they're gonna, do the work and make things better. But it really is like, how are we gonna hold them accountable? So now that we actually have workers who, feel like they're, that they can speak out, how is that going to translate in terms of employers doing the right thing, having good employment practices, making sure that workers feel safe and that there's a way, to have their complaints or, concerns addressed. And I think ultimately, if we can have companies just free their workers from the NDAs, I don't think that's anything we can do legislatively, but, if we're building the momentum on, this topic of what we're, public policy and having workers speak freely about their experiences, let the workers speak. So, I would love to see, this movement move in that direction too.
That's great. And then my last question, and then we'll open up for Q&A and bring our Director of Content, Marion Wellington, on to hear what the audience wants to talk about, is just for you, Ifeoma. Obviously, we're all seeing that unfortunately, it sometimes takes these big high profile moments or high profile individual experiences to radicalize people around structural change and sort of have window into how harmful these practices are. And, often it means that you have to put your story out over and over and over again. And you've really done that beautifully in advocating for this bill and for these changes. And I just wondered, how are you doing? What comes next for you? How has that process been? How are you feeling having gone through this experience now?
I mean, it's tiring, and I really appreciate you noting that. I've had to have the conversation with reporters and others who have asked me without acknowledging what I experienced was traumatic, and talking about it over and over and over is additionally traumatic. But I do think it's important, particularly if we can get these protections, and if hearing the story is what gets folks over the line, I'm happy to share it as many times as it's necessary. For me, what's next is I'm working, as I mentioned, with Open Mic and Whistle Stop Capital on getting shareholders, really, of large companies to hold the companies that they invest in accountable on these issues. And it's always great when CEOs just step up and decide to do the right thing. But I do think that it's important to note where the levers of accountability are. And unfortunately, we've seen it's not always with workers, it's rarely with consumers. And so we're going to the folks who actually hold the money. Additionally, I'm working on a resource for tech workers, and tech workers meaning all of the folks who hold up the tech industry, not just full-time employees, to inform them on what their rights are. And so I'm calling it the Tech Worker Handbook, and really excited about that being public in a few months.
Oh, that's wonderful. Love that. Thank you for sharing. So I want to bring Marian Wellington, our Director of Content, on to hear from our audience and what questions they have. So I'll hand it over to Marian.
Hi, all. And first of all, thank you all so much for this amazing discussion. It's been really incredible to hear your experiences and your expertise in this area. So I hope I speak for everyone in saying deep thanks. We have a couple of technical questions from folks about this, as well as some broader scope questions. One person is not in tech or in California, but is going through a very similar experience to in the workplace. They asked that they said they did not sign an NDA in exchange for money, and they asked how they could use that power to their benefit after you do not sign. So I guess if you have an experience, you didn't sign an NDA, how can you then use that power to help you and others in the workplace?
I want to make sure I understand. Had a terrible experience, didn't sign an NDA, want to use their experience to help others.
I believe that's
I get this question a lot, and honestly, I think it's in whatever way is most comfortable and right for you as an individual, whether that's speaking to others one-on-one who have had similar experiences, whether that's sharing publicly on a platform like Twitter or Facebook or Instagram or wherever else. I think one thing that is really important to keep in mind is that if you've had a traumatic experience, like I said, reliving it through the retelling of it is additionally traumatic. And I think it's so important for folks to have licensed mental health care professionals who are working with them through the process. My therapist has honestly kept me alive through all of this. But I also know that having access to a therapist is a privilege that especially is harder to have when you've left employment or when you've been pushed out of employment. And that's another piece that employers are holding over folks' heads that is just wrong, and a conversation for an entirely different panel about why our healthcare is tied to employment. But I just think folks should keep in mind that you can't help others if you're not helping yourself. And so just think about what you need first before speaking up in a way that may be harmful to you.
Great, thank you so much. We have a couple of questions here that I think might be directed at Mariko about what burden of proof is needed in order to prove discrimination or harassment, and how that impacts speaking up.
Yeah, I was like, wow, there are a lot of questions around that. So in terms of this bill, there are two sections, right? So one deals with settlements. And so it really doesn't, if you're settling a claim, you're not in a court, there's no burden shifting where the plaintiff has to meet a certain burden, the employer you have sort of negotiated a settlement. So in that context, if the claim involves sexual harassment or race harassment, any form of harassment or discrimination, and you are settling that claim, you will be covered. So there's no burden, just if that was an asserted alleged claim that you are settling, you're covered. On the other hand, and I think this is really important, because we wanted to make sure that, again, you don't have to consult with a lawyer to figure out like, okay, am I covered, am I not? You just have to have a good faith belief that what you are, and this tracks a lot of other laws, labor and employment laws, but like our whistleblower laws, which talks about if you have a good faith belief that what you are talking about was unlawful harassment or discrimination, and actually in terms of the severance part or the broad confidentiality clauses that are required as a condition of employment or at the end of employment with a severance agreement, that actually, we have that covering everything, any potentially unlawful conduct, because we want to cover like the whistleblowers, people who want to speak out about any unlawful conduct. But in particular, we call out harassment or discrimination. But again, the only standard really is that you have a good faith belief that the conduct was unlawful and you would be covered by that.
I think a good rule of thumb too, since this is a California law and so it would apply to those who live there, is to just become acquainted with the Department of Fair Employment and Housing and their complaint process and what they consider to fall under this, because if you meet their guidelines, you absolutely are covered by the law.
Great. Ifeoma, this one's for you. I think you may have touched on this earlier and definitely shared about Expensify in the chat, but what are your thoughts about Pinterest announcing that they won't be using NDAs going forward, regardless of what happens with the law, and other companies that have announced they'll stop using them voluntarily?
Yeah, to my knowledge, I have not heard of other companies. And my first, second, and third response to the Pinterest support of the bill is great, but what about all of the folks who they forced to sign agreements like this in the past? I think if you believe in this going forward, you should also believe in it going backwards, and you should release those folks from the agreements that they were forced to sign.
And does this bill help anyone who've signed these agreements in the past, or is it to date moving forward?
If it is signed, it would be from January 1st, 2022, because unfortunately retroactivity is not something that we do often in American legislation, and certainly not when it touches contracts, because that's a constitutional issue. But my hope is, and I'm speaking not as a lawyer, so this is not legal advice, I'll let Mariko stay on mute for this one. As a private citizen, I think that if this law, if it's passed, if it goes into law January 1st of next year, it will be a much harder public relations decision for companies to go after people who sign agreements. Not to say that they wouldn't, because there are some companies who will absolutely make an example of people, but I do think that it provides an opportunity for more transparency.
Great. We have a question that just came up that's, how does one balance speaking up about your experience with trying to get another job and being labeled as a heavy air quotes troublemaker?
Yeah, Ifeoma and I can go back and forth on this one because I can provide some of the like legal perspective, and Ifeoma obviously from like being in that position, you know, I'm also curious what her advice is. I mean, obviously the laws are protecting, I mean, they're constructed to protect workers who speak out about their experience. And so, I mean, just know that if you are raising concerns about unlawful activity and then there's adverse action that's taken against you, the employer's retaliating against you, you know, that is unlawful under our California laws. But no one wants to sue, no one wants to, file action, go through litigation. But I think, again, just in terms of the work that I do, it's constantly about how do we strengthen our laws to make it to prevent the retaliation from happening in the first place. And again, I think the only way that we do that is making the enforcement of those retaliation protections really robust and strong. So I would just say from the legal perspective, again, we really want to encourage workers to be able to speak out and know that they're protected. But how that plays out in the real world, I know is really tough. And I think adding this component of a severance to this bill, because I think a lot of times when someone does speak up, it may not be that they're going to have a settlement, that they're going to actually settle the claim. The employer may just try to push that person out. And in that context where, okay, we think your work is done here, and now here's an opportunity for the employer to try to silence them about what happened, just making sure that we're protecting those workers who get pushed out. It looks like Ifeoma, is she still there?
Either very still or crappy internet. Well, Mariko, I can throw some questions at you while hopefully Ifeoma can rejoin us. Let's see. Oh, yeah. Okay, bye, Ifeoma. This is actually a good question for you. How does forced arbitration fit into the discussion of NDAs?
Ooh, yeah, good question. I would say, they all sort of fall into the same bucket. I think employers have kind of an arsenal of these contract provisions that, it would be really interesting to look back at what employment agreements looked like, like 30, 40 years ago. A lot of times, like employees weren't even signing anything. They just show up to the job and, work. And now, again, I think probably with technology and just these boilerplate agreements that you can just pull off the internet, employers are really putting everything that they can into these employment agreements as a way to prevent workers from speaking up and enforcing their rights. So everything that they can fit into those agreements, they will. And one of those absolutely is forced arbitration. One thing that is particularly troubling about forced arbitration is that the whole process can be confidential. And so that the combination of NDAs and forced arbitration really was, and I hope that this really blew up during the Me Too movement, that is how all the perpetrators were really able to, just go on in terms of harassment and discrimination, over and over and over again. And there was absolutely no corporate responsibility because all of those cases were being resolved in arbitration. So we absolutely need to get rid of forced arbitration. These two things together need to be a fight that we take. It's a little bit tough at the state level because there's broad preemption issues under the Federal Arbitration Act. So I think this is a fight we really need to take to Congress. But making sure that workers are not having to litigate this in a black box, which is shielding employers and perpetrators and wrongdoers, is if we're talking about accountability, forced arbitration absolutely needs to be part of that discussion.
Sorry, we had a power outage. There's a flash flood happening outside right now. So
oh, no.
Kind of crazy New Mexico monsoon weather. I wanted to make a point from right before everything went out from the non-lawyer perspective about what you're risking when you speak up. And unfortunately, to be able to prove an adverse action, you need to have the proof of it. And what I and others have faced for sure is that if you speak out in between jobs, no one is ever going to tell you, I'm not hiring you because you spoke up about your previous employer. So that's something that you've got to keep in mind. I think the way that I try to think about it, the silver lining is I wouldn't want to work for any employer who would have a fundamental issue with me speaking up about discrimination and harassment. But unfortunately, that's many employers. And we live in a society where you need a job to have health insurance. That's something that I've written about, and what it means to lose access to insurance when you have a family you're supporting with it. And so there are real serious things to consider. But I also think that there is a way forward. For me, that was starting my own thing. For others, it's working at smaller places, being upfront with employers during the interview process about what you've done before or where you've spoken up. And so there are options, but I just don't want anyone to think that it's without consequence.
Great. I think we're getting to where we have to wrap up the Q&A portion. Although I did see, as I was just looking, someone had asked how they can help with the final push on the bill. So I don't know if there's a call to action that would be helpful to you both that we should offer up while we're here together. And we're happy to send as a follow-up as well.
Definitely call your assembly member because they will all vote on the bill.
Great.
Yeah,
So sorry, go ahead, Mariko. Sorry.
Yeah, I was just gonna say for individuals who have like real life experience and a story that they want to share, I mean, it may be less scary to do it in this form of like an actual support letter for SB 331, because those letters are so powerful. And now that we're getting close to sending this bill to the governor's office, if we have workers who are actually talking about like, this is how this has impacted me and how this bill would help me, that would be really, really helpful too.
Great.
And then also on the forced arbitration, I would say absolutely, like take that. I mean, I feel so lucky to live in California that we're able to pass really good progressive laws. But at the federal level, we need to keep like pounding on our representatives to get change at the federal level on forced arbitration. So yeah, talk to your representatives.
Excellent. Well, we will send out in our follow-up email how to contact your assembly person and make sure everyone has the tools to do that, the bill number, and a reminder of what Mariko and Ifeoma just shared about sharing your experience if you have it, letting them know so that they vote the right way on this bill. And I just want to thank both of you for the discussion today and for being willing, to share your expertise and your lived experience and retell that with our audience and our members. We really, really appreciate it. And for those of you joining, I would just again encourage you to call your assembly person. And if this is work that you believe in and you want to see these sorts of issues addressed throughout the tech sector, please become a member of TechEquity as we continue to advocate on these issues and more. So thank you everyone for attending today. Thank you again to Ifeoma and Mariko. I hope everyone has a wonderful rest of your day.
Thank you.
Thanks so much. Bye, everyone.